Thank you.
There we go. Okay, good morning, everybody. My name is Dina Falbo, and I'm the chair of the Colorado Board of Mortgage Loan Originators. Today is Wednesday, September 20th, and the time is 9:01. This is a public meeting of the Colorado Board of Mortgage Loan Originators, and we will now call this meeting to order. So let's begin by having Division Director Waters perform the roll call.
Dina Falbo.
Here.
Jennifer Mextroth.
Here.
Shirley Thielen.
Here.
Aaron Saladay.
Here.
And Cindy Emerine is absent today. You have a quorum.
Okay, thank you so much. Let's begin by approving the board meeting minutes from our July 19th meeting. May I have a motion to approve the board meeting minutes from our July 19th, 2023 meeting?
I'll make a motion to approve the minutes.
Okay, before we go to a second, are there any discussion, any changes, anything that needs to be stated about the board meeting minutes? No? Okay, do we have a second?
A second.
Great, awesome. All in favor of approving the board meeting minutes from July 19th meeting, say aye.
Aye.
I am also an aye. Great, okay, moving on. We'll go back to Division Director Waters in regards to any policy matters or agenda items for the next meeting.
So board, do you have anything that you would like to discuss at your November meeting?
Nothing specifically, no.
Okay.
Okay, that's that. Moving on. Public comment. Any person may bring their concerns about matters not on the agenda before the board. Speakers are requested to limit their remarks to 2 minutes unless allowed additional time by the board. Has anyone signed up to speak before the board or address the board this morning?
We do not have anybody signed up, but anybody in attendance, if you'd like to address the board, just please hit your hand icon and we will call on you and give you the option to unmute. And Madam Chair, I do not see anybody wishing to address the board.
Okay, thank you so much, Mr. Turner. Okay, moving on. Before we enter into our complaint matter or licensing matter or AG matters, I'd like to read the script in regards to executive session. I'd like to enter executive session quickly. So this is Dina Falbo, and it is September 20th, 2023, and the time is 9:03. This is a meeting of the Colorado Board of Mortgage Loan Originators, and I move that this board enter into executive session pursuant to Colorado Revised Statutes sections 24-6-402, 3A, Roman numeral 2, to receive legal advice on specific legal questions concerning the legal basis for discipline regarding complaint matter number 2022-1487, and to discuss and receive legal advice on the pending legal actions in complaint matter number 2022-91, complaint matter number 2023-577, complaint matter number 2021-348, and complaint matter number 2023-272. May I have a second?
A second.
I second that.
Thank you. All in favor of moving into executive session, say aye.
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 And I'm also an aye. So this is to inform the public that the board is exiting the public meeting to convene in a closed executive session conducted remotely, and we will be back. Okay, see you over there.
And if everybody could turn off their cameras and mute themselves, please.
What is happening here with mine? Okay, it appears that everybody's back. Can somebody confirm for me that I see members of the board are back? So, okay. Okay, this is Dina Falbo and the time is 9:40 and we are back in open session. So let's move right back to the agenda where the next item on the agenda are complaint matter.
Good morning.
Good morning.
Complaint matter A is complaint number 2022-1487. A complaint was submitted by the listing agent explaining that the respondent presented a pre-qualification letter for the buyers indicating that their credit and income information had been reviewed and that they had been approved. The complainant states that his seller accepted the offer based on the letter and later learned that the borrower's credit was not pulled until 2 days after the property went under contract. The complaint alleges that the respondent failed to properly disclose he was acting in dual capacity. As a result of the loan not closing, the borrower had to stay in a hotel for 30 days, and the seller incurred several unnecessary moving expenses and was also unable to close on an out-of-state property that she was trying to purchase simultaneously. The credit reports in the loan file are dated June 30th, 2022, just 2 days after the pre-approval letter was issued. The lender for the transaction also confirmed that the file was submitted to them on June 30th, 2022, when the contract to buy and sell is dated June 28th, 2022. The loan file contained a dual status disclosure dated July 7th, 2022, several days after the property went under contract. Lastly, the respondent's loan file contained an affiliated business arrangement disclosure disclosing his ownership of the origination company. However, this disclosure was dated 6 days after the application was taken. Possible violations include 1210-713-1Q, 1210-713-1V, 1210-713-1M, 1210-724, 1210-713-1X, 1210-713-1J, 1210-713-1CC, and rules 5.22 and rule 5.6. Disciplinary recommendations are a final agency order, public censure, and a fine of $5,000. And Investigator Martinez can help answer any questions.
Thank you so much, Nicole. The first thing I'd like to say right off the bat, kudos to the investigators on this one. This was a very big job and you did a fantastic job. So thank you so much for making it so clear and concise for us.
Thank you. You're
Yeah,
most welcome.
I appreciate your hard work. Thank you so
Thank
much. So, okay, so I'd like to open up discussion to the board. There's a lot to unpack here, a lot to discuss about what went on and your thoughts and feelings.
Yeah, there's definitely a lot to unpack. So, and I think it's unfortunate because there were so many people kind of harmed because of the actions, you know, not only the buyer, the seller, the other seller. There were a lot of parties that were really impacted by this. And I think that the facts really show that a lot of the documentation was not validated at the time that it should have been, showing kind of incompetency in acting as an MLO. Yeah, I think the work was completely incompetent. MLO
Absolutely.
work.
And I guess I probably can speak to this mostly because I am in dual status. I'm actually a real estate agent as well as a loan officer. And it is very something that really weighs on my mind in that capacity because, you know, it's a lot of stuff on your shoulders to take care of. But first and foremost, you can't have a pre-qual or a contract without even pulling credit. There's absolutely there's no validity to that. And I actually just had this same exact example happen on one of my listings, and it cost us 45 days on the market. And the buyer ended up losing his earnest money, all due to a loan officer. So I really have a capacity to understand where everybody's feeling with this. And, you know, I work with the lender that they submitted this to, and I know you get turnaround time within a day. It is very fast. So even if it didn't approve, we would know within 4 to 5 days if it did not approve. Something that really struck me was the timing on all the documents. Approval for the pre-qual was 6/28, submitted to the lender on 6/30, docs were pulled on, or credit was pulled on 6/30. The docs went out on 7/7, if I remember correctly. And then he locked it on July 21, which is 20 plus days after the application when they were under contract. It's definitely something that I've never seen. And if you had issues with the file, you would, everything would be locked up front. Everything would be secured for that borrower. So I absolutely think there's a big issue with this whole, everything all around in this thing. So.
I think, you're right. And everything that you pointed out. So I think it's not a question of if something was done wrong here. It's just what do we feel as a board, are as the most suited violations in regards to disciplinary action here. So we have the recommendations. Is there anything that we want to add? I mean, this license is currently expired, but due to reinstate in February, so we might consider, the disciplinary action for today, knowing that in case this applicant tries to apply again.
Yeah, I mean, given that, the license is not active in this moment, it is challenging, and I agree with the recommendations, and I think that that is sufficient, and that if the loan officer were to come back and reapply at a later time, we would obviously look at this and consider this in that application. But it is a challenging decision to figure out how much really is enough, because so many people were impacted by this.
Right. I do have one question, maybe to staff in regards to the fine of $5,000. Are we limited to a fine of $5,000, or is it $1,000 per violation, as it has been in the past? Or can you direct me there?
It's $1,000 per violation.
Okay, so the 5,000 was considering those original 5 statutes that were violated. Okay.
I think the maximum fine is warranted. This is gross negligence and incompetence, in my opinion. And this individual should not be licensed. This is a bad situation. So, in my opinion, we should go for the maximum for all of these violations that are outlined.
Okay, we can start by making a motion, which will include the violations and the disciplinary recommendations. I can go ahead and make a motion on that. I'll go ahead and do that. I'll make a motion that we discipline this respondent due to violations 12-10-713 1Q, unworthiness, 12-10-713 1V, good faith and fair dealing, 12-10-713 1M, any part 9 or rule violation, 12-10-724 dual status, 12-10-713 1X, unfair and deceptive practice, also including 12-10-713 1J, failing to provide parties information, 12-10-713 1CC, making false and deceptive and or representation, and also including rule 5.22 and 5.6, meaning then that the fine would be $1,000 per violation. What is that? 5, 6, 7, 8, 9. That would be $9,000 fine. Final agency order, including public censure, and certainly a heads up if this application comes before the board again. Is there anything that I need to add?
And we can't include the rule violation.
Oh, we can't. Okay.
So 8,000.
Thank you.
So that would
Okay, so I would amend that to not include the rule violation.
Well, sorry to interrupt, board members. You can cite as 12-10-713-1M. requires an underlying violation of a rule. So
Oh, I
violation
see.
of rule 5.22 and rule 5.6.
Okay.
Okay.
You can treat each a violation of each rule as a separate count if you choose, or you can lump them together into one count, if that makes sense.
Yes, it does. So I would amend my motion to remove the addition of 5.2 and 5.6, where 12-10-7-13 1M would be able to cover both of those, which would then make the fine a $7,000 fine. Do I have a second?
A second.
Okay, all in favor, say aye.
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 And I'm also an aye. Okay, thank you so much. Okay, moving on to the agenda, we're moving directly to, so sorry here, licensing matters. So, yeah.
Okay, licensing matter A is complaint number 2023-1356. On March 9th, 2015, the applicant's company entered in a consent order with the state of New Jersey Department of Banking and Insurance. The applicant's company was ordered to pay a $5,500 fine, which was paid. On March 13th of 2018, the applicant's company entered into a settlement agreement with the state of New York Department of Financial Services. The company was ordered to pay a $5,000 fine, which was paid. On April 14th, 2019, the applicant's company entered into an order to discontinue violations with the state of California Department of Business Oversight. The company was ordered to pay a $1,000 fine, which was paid. And we do not have a recommendation. Investigator Martinez can answer any questions.
Thank you, Nicole. Okay, so the most recent offense was about 4 years ago, and although these 3 items do exist, they aren't specifically to the person as an LO. So I have a positive opinion of this, but I'd like to open it up to the board and see what your thoughts are.
Well, I had a question. None of these were disclosed on the application. Is that correct?
That's accurate. They were disclosed in the NMLS registry, though, and oftentimes, I think because of the fact that most states require the disclosures to be in the NMLS registry, there may be some disconnect in terms of disclosing them specifically on the Colorado app, but they were available in the NMLS registry prior to him submitting the application.
Okay, thank you.
No problem.
Yeah, go ahead, Jennifer.
Oh, I was just going to say, I agree. I have a positive opinion. Obviously, I expect executives to have some control and understanding of the rules and regulations and to abide by those. But I didn't think that any of the violations for the company itself were egregious or anything. And so I also have a positive opinion against this loan officer personally, the applicant.
I have the same feeling as well. So
Yeah,
I would
Go ahead.
agree.
yeah.
I would agree. I mean, I think that he, there was a little bit of carelessness in not supervising employees, but I agree. It's been 4 years and I'm on board with the positive.
Okay, do we have a motion
I'll make a motion to approve the application.
and a second?
I'll second it.
Okay, all in favor for approval of this license application, say aye.
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 And I am an aye as well. Thank you.
Okay, moving on to licensing matter B. This is an application. It's complaint number 2023-1220. In a multi-state investigation, it was determined that a former NMLS education provider, Reese State Educational Services, completed in-person and online education on behalf of hundreds of MLOs across the nation. Reese granted course credit to the MLOs who had enrolled in the approved courses, but who neither attended the course nor completed the coursework necessary to receive course credit. As a result of the resettlement, the respondent agreed to the following: to surrender all current MLO licenses and withdraw all MLO license applications of participating state mortgage regulators, to wait at least 90 days from December 31st, 2021 before applying for or seeking reinstatement of an MLO license, and to pay $1,000 in administrative fines to the Colorado DFPI, the state mortgage regulators. As usual, there is no recommendation, and myself and Investigator Levy are here to answer any questions you may have.
Thank you, Sarah. Very appreciated. So as been typical of this board, we don't have much patience for this REIS scheme and the people who participated in it, but as noted, each individual case is different, and we have to take into consideration what was done, what was said, how it was handled, and the results of the settlement, that how the respondent handles the settlement. So I'd like to open it up to my fellow board members to see your thoughts on this particular respondent in regards to the failure to report, as well as the REIS scheme in its entirety. What are your thoughts?
Well,
Go ahead, Shirley.
thank you. Her letter states that the employer, whoever she was employed by, required her to use this company that's subject to the scheme, or that put the scheme forward. I feel like she complied with everything that was required. She fulfilled the requirements of, waiting to reapply. And so I would, and she has recommendation letters. So I would approve her license.
I'm right there with it. And then also maybe doing the probationary license, that's the 180 days, so that there is just some accountability during that period.
Yeah, I agree. I do think we have obviously seen this situation in the past where there's been no letter of explanation, no letters of recommendation. And so in this instance, I appreciated all of that documentation being in the file. And that does, give me a positive opinion on the applicant.
I agree. I appreciate always taking the time to provide the letters of recommendation in case anybody's listening. It always seems to help a little bit if you do that.
Mhm.
And also a good letter of explanation. So for that reason, I would agree with all of you on your opinion to move forward with this license. So does anybody like to make an motion on this?
I'll make a motion, positive for licensing. And then can we add on their probationary license for the 180 days? Since that seems like what we're going to do with most of these nowadays.
I think that seems, right. I think that seems agreeable. Do we have a second on this?
I'll second.
Okay, all in favor to approve this license under a probationary license time period of 180 days, say aye.
Aye.
And I am also an aye. Thank you. And just a quick question. So staff will help make sure that the message is sent and that 180 days is noted.
Correct.
Okay.
Yes, absolutely.
Yes,
Yep.
we will.
Thank you.
Okay. So moving on to licensing matter C. That is complaint number 2023-1042, and it's an application. On July 21st, 2021, the applicant was convicted of a misdemeanor domestic assault, 4th degree, and an assault in the 4th degree misdemeanor. The applicant was sentenced to 2 years probation and a fine of $141.50. The applicant has paid the fine in full and completed probation. Tabitha Quinton is here to answer any questions, and there is no recommendation.
Okay, thank you so much, Sarah. So this individual has 26 licenses. It is licensed in 26 other states. And I don't know, I'm just going to open up the floor to you all to have your opinions and discussion about this particular case.
Tabitha, I do have a question for you. On our application, when it asked him if there had been any felonies or misdemeanors or anything like that, he had actually said no on every one of those. Do you know if any of his other applications for the other states actually showed no on those, or were they disclosed at that point?
You're muted,
You're
Tabitha.
muted.
Sorry, I don't know what was put on his other applications.
Do not. Okay.
So just to confirm, his probation has been completed. It seems like there were, like, he had a statement in there saying he still had a year, but it wasn't dated. I was really pretty confused on
Yeah,
this.
me too. Mhm.
Yeah.
I mean, I believe it's still ongoing.
Yeah, the work that I found, so his offense was 7/28/21, so it's going to be in somewhere in that point. I think it was a few more months, if I remember correctly.
Right, there's some time still left on this one in particular. And I have to say, just for the record, that I was annoyed by the letter of explanation,
Yeah.
basically blaming the two victims, didn't take any responsibility. And so in my opinion, basically lied about it, about what happened, lied to us about what happened in the letter. Because the police report and the two victims' statements all line up, what actually happened. And he made no reference to the fact that he was drunk, and that obviously he took anger management course, but no mention of, I was wrong, I wish I wouldn't have done that, I rehabilitated and I learned something at the anger management. And I'm afraid, my fear on this particular respondent is that lying is okay and anger is okay. So no mention at all of how I didn't mean to do that, I shouldn't have done that, it was terrible choices, anything, such as that. So I have a negative opinion on this one.
And I apologize, I don't want to cut in here, but we did call the courts and he has completed probation.
Okay.
And paid his fine. So I just wanted to make sure.
Thank you.
That was
Thank you.
after the report was completed, that time came. So he has successfully completed probation.
Thank you.
Thank you,
That's
Sarah.
important.
Dina, I agree 100% with you. It doesn't seem like there was any remorse. His story was completely different from what apparently actually happened. It also said he's filed bankruptcy within the last 10 years, I guess. I don't know how recent that was. Maybe I missed that, but I saw that he had checked that. I have a negative feeling about this one too. But based on the facts of the case.
Right.
And not to interject, and I apologize, but I do want to make sure that you all consider the factors of a criminal conviction that is statutorily required. And those include the nature of the conviction, whether there is a direct relationship between the conviction and the position's duties and responsibilities, and if the conviction may have any bearing on the applicant's fitness to perform such duties and responsibilities, any information produced by the applicant or provided on his or her behalf, and the time that has elapsed since the conviction. Yes, just wanted to make sure that you consider those factors when making your decision.
Thank you. Yeah, because that's kind of where I landed. Is I'm having a hard time tying the conviction directly to the potential impact of MLO activities.
Agreed.
And I know that obviously in the letter of explanation, there definitely was some potential lying, and that's not great. But from an MLO activity standpoint, I'm not sure that letter of explanation would directly tell me that he or she is unfit to conduct MLO activities or would lie to the potential consumers. So I have a little bit of a hard time, and because of that, I feel like I have to have a positive opinion because I'm not able to tie these crimes, and you know, they were a couple years ago. I'm not able to really tie that to any MLO activity, and
You're
how that
so
would
right.
potentially impact.
You're so right, Jennifer. It makes it difficult. I feel like it's the predicament that we're put in when, yes, I agree 100%. I don't see the direct connection except for the lying part maybe, but the fact of the matter is, as much as I would like to deny and have a negative opinion, I can't fully do that off of what we've seen in regards to a statute to uphold that. So I just wanted to place it on the record that I'm not happy about the letter that we read, and hopefully that message is sent that it's still not okay, but right.
I'm right there as well. The letter was totally different than what everybody else had put there. And I can understand, you know, maybe forgetting one, but when there's 4 questions, misdemeanor or felony, and you are still in probation for that, you know that you're in there. It does not affect his abilities to do that. But what I would like to know, I'd like to ask is, if we did put in a positive for the licensing, is there a way that we can attach, and I like this, the probationary license for the 180 days on this one, just to make sure?
I agree, Aaron. If we're going to allow the license to be issued, I would definitely like a probationary period attached.
All right.
You can do that, board.
Okay. Thank you, Marcia.
Okay, would someone like to make a motion?
I'll make a motion for a positive for licensing with attachment of a probationary license for the first 180 days.
May I have a second?
I'll second.
Okay, all in favor of approving this license on a probationary license for 180 days, say aye.
Aye.
Sorry to interrupt.
Okay.
Members, just wanted to make sure that you include the legal basis
Oh, sure.
for your consideration for the probationary license.
And the legal, which one would that be in regards to the statute?
Based on your discussion, potential violations or bases would be 1210, 713, 1N, which discusses various crimes, various statutory crimes in Colorado, and like crimes. You can also go for 1210, 713, 1Q, demonstrated unworthiness or incompetency to act as a mortgage loan originator in a matter that endangers the public. So those are both bases for denial, or not denial, but for the probationary.
Okay, Aaron, would you mind restating your motion, please, and including at least one of those?
Absolutely, yes, ma'am. I would like to make a motion to make it a positive for licensing. Per our discussion, I want to note with a probationary period of 180 days of a license per 12-10-7131N.
Okay, may I have a second?
I'll second.
All in favor, say aye.
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 And I'm also an aye. Thank you.
Alright.
Oh, sorry about that. Go ahead. Go ahead, Sarah.
I don't mean to rush you guys, sorry.
No, you're fine.
So matter D is an application. This is complaint number 2023-1404. On May 23rd, 2023, the applicant was convicted of a class 1 misdemeanor, child abuse, knowing reckless bodily injury. The applicant was sentenced to 18 months deferred judgment sentence and 2 days jail with credit for time served and a fine of $1,874.50. The applicant is set to end their deferred judgment on December 28th of 2024, and the applicant has paid the fine in full. There's no recommendation, and Tabitha Quinton is here to answer any questions.
Thank you so much, Sarah. Okay, so this one is interesting because I would have a positive opinion on this one. It was a car accident. There was some alcohol involved. The downsides are it was only 3 months ago, and he's still involved in his deferred judgment time period, which doesn't end until December 28th of 2024. So, as typical of this board, we don't generally approve licenses where probation or fines are still active. So I open up the floor to you to discuss.
And sorry to interrupt board members, just to, much like the last one, please remember the 4 factors when determining the nature of the conviction, whether there's a direct relationship, any information produced by the applicant, and the time elapsed.
Great. Thank you so much, Anthony. We appreciate that.
I'll start. I don't see this being a one-time thing for him. And you know, the mother of the child actually wrote a letter for him and everything. I totally agree with, you know, reapplying after the probation period is over. And I don't think that this would actually stop him from being a good LO. But I do agree that if there's a probationary period, that we probably shouldn't have a license for that portion.
I agree completely, Aaron. That's well said.
Yeah, and I think we're pretty consistent on this. So, I mean, I agree as well.
So maybe in consideration of this, we can choose to deny with the option to withdraw the license and invite the applicant to reapply after probation is completed. Would this be acceptable?
That's perfect.
Okay, why don't we make a motion on this? Does anybody would like to make a motion, or I can do that?
And please remember to cite the statutory bases. Sorry to interrupt.
Yes, sorry,
No,
thank you.
I was just gonna ask what bases we would want to use for this one.
Based on your conversation, some potential bases would be 12, 10, 7, 13, 1N, which is provides a list of criminal conduct and like crimes. And so that's one basis. 12, 10, 7, 13, 1Q, demonstrated unworthiness or incompetency to act as a mortgage loan originator by conducting business in such manner as to endanger the interests of the public.
Okay, perfect. I'll make a motion to deny this application with the opportunity to withdraw based off of 12, 10, 7, 13, 1N.
May I have a second?
I second.
All in favor, say aye.
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 And I'm also an aye. Thank you so much. Okay, that completes our licensing matters. Moving on the agenda to our ESP matters and Miss Penny Elder. Do we have any ESP matters?
She's not in attendance, and there is none.
Okay, thank you so much, Eric. Appreciate that. Okay, next on the agenda, moving into our Attorney General matters. Okay.
I'm not sure if Gina Kanan is in, and if she is, she may need to be unmuted.
I don't see her, but
Let's just she is here. If Eric wouldn't mind giving Gina access to speak, please.
There she is.
Hello, board members. Complaint matter 2022-91 is back before you for reconsideration based on the narrowing of allegations in the proposed notice of charges that will be filed by the Attorney General's office. Do you have any guidance for me on which charges you would like to see on that notice of charges and the discipline appropriate for those charges.
Well, I think the board might agree that to agree to violation of Rule 5.9 only.
I agree with that.
Mhm.
I agree also.
Do we need to take a vote on that?
Yes, please.
Okay, all in favor of to agree to the violation, amending this one to the violation of Rule 5.9 only, please say aye.
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 Oh, I didn't ask for an, I'm sorry. That was my motion, and may I get a second? Sorry about that, everybody.
I'll second that.
Okay, thank you. May we get a motion, or may we all in favor say aye?
Aye.
Aye.
And
Aye.
I'm also an aye. Thank you. Sorry, get my words all jumbled up. Okay, so moving on to the next matter.
Sorry,
Thank
do you have a recommendation, Dina, regarding the appropriate discipline based on that violation?
Well,
That's right, because it was 3K and 12-month suspension. So, right.
Is it possible to do like $1,000 fine with a suspense till he responds to the board?
that's what I was going to say. The $1,000. Yeah, guidance for discipline. Yeah, so we would amend with a $1,000 fine to that motion.
But what about the suspension piece?
Well, let me open up. I'm going to take a look.
So the original suspension recommended was for 12 months. You have a variety of options, including no suspension, a suspension for 3 months to, whatever time period you deem appropriate, a suspension until he responds to the complaint, or an alternative suspension, 3 months or until he responds to the complaint, whichever is later.
I think that would be appropriate until he responds to the complaint. This is the problem. He's never responded, right?
Agreed.
Right. So we would like to add that until he responds to the complaint. Are we all in favor of this, adding this in regards to that?
Yes.
Yeah.
Absolutely.
Okay, all in favor, say aye.
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 Is there anything else we need to add, Gina?
No, thank you so much.
Okay, thank you. Okay, so next is the complaint matter 2023-577 is also a reconsideration.
Somewhat, yes. It's a settlement proposal from the license applicant. This is a Reese matter. Was previously denied. Since that denial, the applicant has provided additional documentation, specifically a personal statement, as well as 2 letters of recommendation. And the applicant has proposed a stipulation where the applicant receives a probationary license, and that probationary license is for a period of 180 days. There is a signed stipulation from the applicant himself, just pending board's thoughts and approval.
Okay.
If I may start, if I remember correctly, the reason that we declined this the last time was there was absolutely no response or rebuttal from him or any of his side to it. And we basically wanted just to hear his side to this. Do I remember that correctly?
I believe so. That's how I remember it as well.
Yeah, and now that we have it, I'm totally fine with the recommendation. Again, if you're out there, we just want to hear both sides. If we don't hear your side, obviously we can't have any conclusion to draw from for you. So I'm totally fine with the recommendation to reinstate with a positive, and then do a recommendation to give a probationary license as well.
I agree with you so much as well. I always appreciate the letters of recommendation and a statement. It really, as you said, helps us. So I appreciate that. And I agree that to reconsider the items that were proposed. So,
Yeah, I would agree. Do we need to do a motion to accept the proposal?
Yes. Yes.
Okay. I would make a motion to accept the proposal. Do I need to actually outline it, or is that good?
I believe that should be good.
To the
It would just
probationary
be a
license.
motion to approve and accept the proposed stipulation.
Okay.
Do we have a second?
I'll second that.
Okay, all in favor, say aye.
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 And
Aye.
I'm also an aye. Thank you so much. Okay, moving on to the next complaint matter 2021-348. As an update, we received an update on this one, so I think we're fine with moving forward. We received the status report. So moving on again to complaint matter number 2023-272, same thing. We also received a status report update on this one as well. So nothing further needs to happen or take place on that at the moment. So that is the end of the Attorney General matters. So moving on to agenda items for the next meeting. Do we have any discussion about the next meeting or items that we want to add to the agenda? Anything from Marcia Waters?
I don't have anything for you board members.
Okay. Anybody else?
I don't have
Okay.
anything.
Okay, well then the next item on the agenda is adjournment. May I have a motion to adjourn this meeting?
I'll make a motion to adjourn the meeting.
And a second?
I second.
Okay, all in favor, say aye.
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 And I am also an aye. So this meeting is adjourned. And our next scheduled meeting is set for November 15th at 2023 at 9 a.m.
Awesome. We will see you then.
Thank
Yeah.
you, everybody. Thank you
Take
so